The body proceeded to discuss the next topic, Chapter 16 of the Fire Safety Certificate of Inspection. Attorney Taniegra and Mr. Sumugan manifested that since there is already Fire Safety Inspection Code, this chapter should be repealed inasmuch as the ordinance is actually mandating the functions of the Bureau of Fire and Socoteca II. Furthermore, Attorney Taniegra argued that this is no longer within the jurisdiction of the local government unit to set regulatory policies prescribing the functions of the GOCCs or public utility corporations, inasmuch as the same are typically governed by their respective charters or mandates. Honorable Beth Bagonok presided on the review of consumer welfare and ruled out for the repeal of Chapter 2 concerning the provisions on the use of formaldehyde and other chemicals as food preservatives, as Attorney Taniegra affirmed that the similar substances identified as poisonous, injurious, deleterious substances had been covered by the RA 7394 or the Consumer Welfare Act, which was accordingly upheld by the Honorable Meg Santos, Mr. Bailas, and Mr. Bueno, and the motion to appeal has been put forwarded by the Honorable Meg Santos thereafter. Moving on to the provisions concerning the operations of movie houses, Honorable Meg Santos moved for the amendment on the penal provisions upon the suggestion of Attorney Rosendo Roque to increase the amount from 500 to 1,000 and the word imprisonment be deleted subject to style. Furthermore, a provision incorporating the implementing rules and regulations and to become the Section 3 of Ordinances 621, Series of 1987, has also been suggested upon the motion of Honorable Meg Santos. As suggested, Ordinance Number 26, Series of 1964, be reinstated and consequently Ordinance Number 62, Series of 1987, or Letter B of Chapter 3 under Consumer Welfare, is thereby repealed for the reason that the prohibition should be made mandatory instead of just putting a standby room only sign. Instead, Mr. Bueno suggested deleting Section 1, then Section 2 will become Section 1, while Section 3 will adopt the penal provisions as suggested by Attorney Rosendo Roque, subject to style. The 10th en banc hearing for the Codification project was presided by Honorable Vice Mayor Sherlyn Banyas Nograles, together with Honorable Elizabeth Bagonok, Honorable Virginia Liedo, and Honorable Eduardo Layson IV, and proceeds to acknowledge the participants, observing students from NDDU, and various representatives from respective offices. It was Chapter 7, or the Ordinance on Consumer Welfare Desk, bundled under Consumer Welfare, that was given priority at that time because the small establishments are required to put or install suggestion boxes and the big establishments to set up consumer welfare desks among the respective premises so as to provide a mechanism whereby the consumers could ventilate their concerns. After a dynamic discussion for more than a couple of hours, there were 4 provisions that were thereby amended, which are: under Section 2 of Ordinance 24, Series of 1993, as amended by Ordinance 18, Series of 2002, the definitions of small and big establishments being revised to be consistent and conform with the relevant national laws as well as other related local codes such as the investment and local tax codes. As proposed by Mr. Arnel Saico, the DTI officer in charge, the definitions will be: small establishments refer to micro, small enterprises whose asset sizes ranging from 3 million and below for micro and 3 million to 15 million for small. Big establishments refer to the enterprises whose asset sizes ranges from 15 million to 100 million for medium enterprises and 100 and above for large enterprises. Number 2, Section 3, which was labeled as Strategy covering 8.1 and 8.2, such shall become the objectives of the ordinance as proposed by Attorney Taniegra. Under Section 3B.2, Paragraph 2, wherein agencies involved has been expanded to include other concerned agencies, hence it will be read as, complaints which cannot be settled at this level shall be referred to local and national government agencies such as DTI, DOH, that's FDA, DA, or any other offices which has jurisdiction in resolving consumers' complaints or similar concerns. In Section 3, C.1, the revisions being introduced by Honorable Bagonok address the issue of the time frame or response time required among the establishments to act on the complaints and suggestions simultaneously, such that the revised form becomes: suggestion boxes shall be installed in small establishments for the management or owners to act on every complaint immediately but not more than 3 days, and for every suggestion for management's discretion, subject to style. There were also a lot of enhancements proposed in the above-mentioned ordinance, and these are: Mrs. Asuncion Rodriguez, an ardent consumer rights advocate, insisted on the immediate opening of the suggestion boxes every day at the end of the business operation in the presence of a deputized public servant. Barangay Captain Veneracion favored the adoption of the standardized complaint form with detachable stub retained to the consumer to serve as a reference for the complainant and as an evidence of violation for the monitoring agencies in case of establishment failure to act on filed complaint. Attorney Roque also suggested for the segregation or differentiation of the complaints and suggestions. Creation of the task force to be commissioned as a composite regulatory body to complement the various implementing bodies such as DTI, DOH, FDA, or DA, as purported by Mr. Bueno, which was thereby affirmed by the DTI officer in charge. While there are also a number of participants who purported on the need for various local government offices to have a consumer welfare desk, Attorney Taniegra maintained later that such and other relevant provisions should be treated separately inasmuch as the ordinance is focused only on ensuring that there are mechanisms among establishments whereby the consumer could ventilate their concerns or redress grievances thereto. The Honorable Vice Mayor concluded the hearing by reminding the DTI officer in charge to bring the complaints form so that the same will be tackled during the subsequent en banc hearings, while she further encouraged that the provisions that needs to be inserted to enhance the ordinance should be submitted beforehand in order that process could be expedited thereafter. There are more chapters to be discussed today, and hopefully, when the aforementioned draft passes the third and final reading in the plenary session, then the City of General Santos will come to behold, for the very first time ever, a duly enacted General Santos City Code of Ordinances. With this enactment into local law, this significant milestone of legislation will become the 16th Sangguniang Panglungsod's main legacy to the city's history and development.